Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, good afternoon, everybody. I'm Andy Fowler, and I'm here with Sean St. Clair. We're live from the Arizona Buy and Hold Real Estate Investor Meetup taking place here at Scottsdale Area Association of Realtors. If you're watching the show, we really appreciate you being here. We think you'll see the value of what this meetup can do. We want to remind you, follow us on Facebook, on YouTube as well. You can find us at YouTube at InRem Podcast. That's at InRem, REMPODCAST. You can find us there, subscribe. We really appreciate it. With us today to start it out, we have Augie Panev, who is the founder and beginner of this meetup. Thanks for being with us, Augie, and thanks for having us to the event.
Oh, no, I appreciate it, guys. Thanks for coming and setting up all this for us and doing it live.
Yeah,
It's the first time. And a lot of people have been asking to have this streamline on Facebook or YouTube. So now you can help us actually do it.
Yeah. So tell us about the meetup. We'll give our listeners and everybody watching, maybe who hasn't been here, a little bit about it, the background, and what they can expect from it.
So what we started with is doing events specifically for investors that are looking for long-term investments, like a buy and hold rental properties. And the event is for networking and finding good vendors, like-minded people, and also we provide really good education. Like today, Sean is going to be talking about subject to wraps. Every time we have some kind of a professional that explains and helps your business and either save money, buy more properties, and just overall help you build your wealth.
Yeah. So it's obviously a great opportunity for experienced real estate investors or even new investors.
Oh, even new investors, just come and meet people, ask questions. We have a bar, food, so it's nice event and nice people too.
So it's a chance to grow your network. But two, you mentioned, we know Sean is going to be speaking today, but give us kind of a flavor of some of the topics you guys have covered in the past.
So my personal opinion is, in order to be a good real estate investor, you cannot just know real estate. You need to know four big topics in order to fully take advantage of the investment side of the business. So first, you need to know real estate. That's obvious. Second, you need to know taxes. Third, you need to know financing. And fourth, you need to know the legal structure, how to structure your business so you protect it. So real estate, buy it to make money, taxes, the tax code, so you don't have to pay a lot of taxes. Financing is because there's so much cash you have. If you use leverage or other people's money, you can grow faster. And all this, when you put it together, then you have to be able to protect it with special legal structures. So we bring people specializing in all these four areas and directly advising and giving tips how to set up your business.
How long have you guys been doing this event?
We're going on a year now.
Okay.
Yeah.
Okay. So give us a little bit of a rundown of what the viewer can watch tonight, or what they're going to be seeing tonight, and what they can expect from future events if they want to come.
So I asked Sean to come and do a presentation specifically for subject to and wraps. First, one reason for that is at the moment, I don't know if you know, guys, but today interest rates hit 7%.
Okay.
So, knowing how to do creative financing, take over existing mortgages, it's a good thing to have. It's going to open your possibility to buy more properties. However, a lot of people just know subject to and wraps as a topic, and they think that one addendum added to the contract is going to do the deal. However, when I sit down with Sean and I ask him, "Hey, Sean, can you help us set up this legally?" I was surprised he sent me 12 different documents that I have to add. I was like, what the hell? So I say, okay, you got to come and talk about this and give everybody the real deal behind the scene, so they know that all the legal stuff that needs to happen in order for you to be secure and do it properly. So
Very interesting. Well, Augie, we appreciate your time here. We know that a lot of people are milling around expecting to meet the man in charge,
yeah,
grow their network, right?
and there's some nice guests here, so I'm gonna walk around and bring some people here, so maybe they'll have some questions and interview.
Awesome. Thanks so much, Augie. We appreciate your time. Yeah, for the viewer, we're going to be doing a couple things tonight. We're going to be interviewing a few real estate investors that are here today, that are attending the event, telling us what they're doing and and the activities that they're up to. We're also going to be answering any questions. So as we transition into interviewing some real estate investors that are here, why don't we start with a question that we have, Sean? Um, I'm going to pose this to you because I'm reading the question and we haven't heard from you, and a lot of people are tuning in to hear from you, right? I'm new to real estate investing. When should I be thinking about meeting with a lawyer and finding out what my options are?
Well, if you're new to real estate investing, I think you should meet with an attorney right away. A couple of reasons. Number one, you want to make sure that your business structure is appropriate for the type of transactions that you're engaging in. Um, Number two, you want to make sure that you have all the right forms, that your contracts have all the right terms and clauses, and that type of thing. So I would say right away, as soon as possible.
All right. So even as you're thinking about it. All right. So we've got all right, we're going to take a break just briefly, and we'll be right back with the viewers here shortly. All right, everybody, we're back. Thank you for your patience working through just a few technology issues. So, our first investor today, we have Denise. Denise, if you would introduce yourself to our listeners.
Hi, I am Denise Holliday. I'm an attorney who represents landlords in landlord-tenant cases.
Okay, so Denise, what brings you to the meetup today?
Augie asked me to come in and be available to answer some questions. One of the things we like investors to understand that if you're going to be buying the property as a rental, that you're familiar with the landlord-tenant laws, that you're not using an online lease that may be not appropriate for Arizona. There's some special laws that punish you if you use some clauses that are illegal, and basically, so you're in compliance with the law.
So you don't advocate winging it, I take it.
Absolutely do not advocate winging it.
Have you been to the event before?
Yes, yeah, I've been here multiple times. Think it's a fantastic event. Was thrilled that he created a place for investors to come and really network, but also get some really good information.
Now, you said you're a landlord-tenant attorney.
Yes.
Are you yourself a real estate investor? I imagine as a landlord and tenant attorney, you represent lots of real estate investors. How long have you been involved in real estate
About 30
investment?
years, and I have several rentals of my own.
Okay. So you know it, you're familiar with it on a professional and a practical level.
Yep, I'm also a pro tem judge for about 25 years, so I can see it from the bench side too.
Okay.
Hey, Denise, talk to us a little bit about some changes in the law that have happened recently. I know, especially with short-term rentals, what's going on with the legislature and how's that impacting landlords?
Well, as most of you know, we got the really great law a few years ago that stopped cities from prohibiting short-term vacation rentals. And we had a really great Supreme Court that helped explain the right to potentially have a short-term vacation rental. And then all of that kind of went to hell in a handbasket, frankly, because they just passed a law a few weeks ago that allows each city to create their own special rules, let's call them, as long as they're tied to like a health and safety issue, which could really be anything. And so we've seen some interesting thing happens in the last couple of weeks about the occupancy size, the number of people that can be staying in the house, which is not the same as occupancy standards in the state of Arizona. So if you own the house, you can have more occupants than if you're renting the house. And they're not even following necessarily the Landlord Tenant Act, which would be 2 persons per bedroom. And so we really see that we're entering a new era, I think, that probably may go too far, then will cause some new laws to come back next season, next legislative session to tighten it back up again, I think.
So we're probably going to see some local municipalities passing some health and safety regulations that go a long ways to stamping out short-term rentals within their communities, you think?
Exactly. One of the
Yeah.
ones I just saw was it's a 5 or 6 bedroom home, and they said you can have 6 people. And some of those already have a vacation rental agreement in place. That person already has rented it, say, maybe for the Super Bowl. And so it'll be interesting to see what that fight looks like and whether a new law could impact an existing contract, which was completely legal at the time that it was written. I think we're going to see probably some legislation that'll adjust that, but it's some litigation that will now fight that, I think.
Do you think, because they've really left it to the municipality level, haven't they, to kind of regulate this? Do you anticipate kind of a real patchwork approach to this? I mean, all these municipalities are governed differently. Maybe they have different interests at stake. I imagine we could get a lot of different requirements.
I do. In fact, one of the things that I've been advocating pretty strongly for about 10 years, and I'm not a big fan of laws, by the way. I just think that the more we have, it's harder to navigate what those laws are. But I think we need a short term vacation rental act. Other states have that. We have a mobile home park act, an RV park act, a landlord tenant act. We probably need a short term vacation rental act so that it's consistent. So when you're buying property in the state of Arizona, you have a consistent set of rules that are not subject to change very often. And talked to the commissioner of real estate about that, both our previous one and our new commissioner, and they are not very eager to step into that. And so you've got to really create a body of people that care enough about that to create a whole body of law and create a new act.
I want to change the topic a little bit here and jump into actually a topic that I'm going to cover tonight, which is lease options. And, obviously you're a pro tem judge, you do tons of landlord tenant work. And one creative strategy for, buying and selling or acquiring an interest in property is to do a lease with an option to purchase. How are the JPs or justice of the peace or the commissioners at the Superior Court, how are they dealing with evictions where there's an option lingering out there that maybe the tenant brings up or says, "Hey, I got this option." Are they, what's kind of their stance and how are they dealing with those cases?
Sean and I have both been attorneys a long time, and we've watched the cycles. And one of the cycles we saw for a while was these lease options or lease purchases. As a litigator, I don't like them, and as a judge, I really don't like them. And part of the reason why is like we can't tell what it is. Is it a cat? Is it a dog? It looks like a cat dog, and I don't know what law applies. And so, really, as long as they're good contracts that say this is a freestanding lease that references an option, and the option potentially is a freestanding document where they can be carved apart if one is breached. That's going to help the litigation if it goes south. And crafting all of those necessary terms is something that we are learning from going backwards in time, 10 years, 20 years, 30 years, and see where is the litigation gone? What did the courts not like? What did they call was basically an equitable interest that now is something that has to be litigated differently than a regular eviction action. Evictions are 2 weeks from top to bottom, in and out, done. Civil action could be 2 or 3 years. And so parties going into those kind of contracts need to know that, because that's going to adjust the price element and the risk factor. And so I think what we've done as litigators and people who write contracts is read all of those bad decisions or harsh decisions and say, how can we craft something that doesn't look like that and is clear and resolve some of the issues that some judges didn't like.
Yeah, and that's one thing when you talk about it being a freestanding lease. I actually honestly don't even want the option referenced in the lease at all. Now I'll reference the lease and the option and say lease in performance, right? And say, if you breach the lease and are evicted, then the option goes away as well. But yeah, I've seen where these justice of the peace, the minute they hear option, they're like, nope, Superior Court, go file a civil action, because now they have some form of interest, equitable or otherwise, in the property beyond just a possessory interest or right. So,
and it could take months just to get the case transferred.
Mm-hmm.
And before you even litigate it. Now, luckily, all the commissioners that we have currently are really solid and understand the difference and how to kind of bifurcate those two issues. So the litigation in the Superior Court is not that complicated. We've got some really solid commissioners that has been very helpful. And I would tell anybody who has a lease option that's gone south, don't file in Justice Court. Go directly to Superior Court in the commissioner level, so that you're not taking the risk that a decision could be made that can't be overcome, and you're in the court where they understand those issues and separate them. And I totally agree with Sean. I like the fact when a lease is a freestanding lease, but the option references this particular potential ownership interest in the property, and that there's a lease and that they tie them together, but only on the option side. I totally agree with that.
So talk to our listeners, because I think a lot of times, especially, we're here at Buy and Hold, a lot of landlords think, oh, well, if I'm going to evict, I have to go to Justice Court, but that's not true. You could actually go to Superior Court and have a commissioner handle the eviction. What's the difference between going to Justice Court and going to Superior Court, and what's the benefits of both jurisdictions?
So Justice Court is quick. You're in and out in a couple of weeks, and you have a constable executing the writ of restitution, so you're going to be done a lot quicker. The writ of restitution will be issued and executed within 5, 6, 7 days at the most. Superior Court is about 10 times more just in the filing fee. The filing fee in Justice Court's about $55. It's about $450 in Superior Court. The biggest issue is getting on their docket. Superior Court is pretty backed up, and so there's not a lot of space. So getting a court date, the initial court date, the law says it has to be heard within no less than 3 days, no more than 6 days. In Superior Court, you're going to have an issue, and you're going to not be even in front of the judge for 3 weeks or so, even though statutorily that's outside the time frame. Then if they plead not guilty, you're not going to see a trial for about a month. And then when you get a judgment and the writ of restitution, it takes about 3 or 4 or 5 days for the commissioner to sign that. And then you got to come back and pick it up and take it to the sheriff's department. And that's just not a big deal for them. It's just a civil eviction order, and they don't really have time for those. And so it may take you a couple of months, at least 60 days to do the lockout. So what could have taken 2 or 3 weeks is now 3 or 4 months. I would tell everybody, really don't go to Superior Court unless the rents that are owed are more than $10,000. So evict them before it gets to $10,000. Or if it's a blended contract that's more complicated, then make sure that you're with a commissioner who is a trained attorney. Justice courts, we have very few trained attorneys. They don't have to be an attorney to be a justice of the peace. And so if it's going to be a complicated issue, move it to a court that can handle that complicated issue.
Very interesting. Well, we appreciate you being here. One final question we're just kind of asking all of our investor friends here is, What's your favorite investment strategy? And maybe that's obvious having spoken with you. You're at the buy and hold meetup and you like to do landlord tenant. Is that your favorite investment strategy?
It is a buy low, sell high. That's, yeah. I can tell you commercial is rough right
Yeah.
now, and it's been rough for a while. It's a big risk, big gains, but big risk. Residential has always been a solid investment here in the state of Arizona, even in the bad times, which we may be headed to some softer times right now. As long as you're in for the long game, it's always a solid investment, just not buying too high. But really getting a good return. We're still short inventory, and so residential rentals, especially residential homes, are still really good buys because you're going to get a good return for your investment. Just the rents are really decent amounts right now. So I think that's the best bet is buy, hold it, stay, keep it in the long run. This is not something you're going to really be able to flip very quickly if we go into a down economy. If you can, terrific. But if you have to, this may not be the market for you.
Very interesting. Well, Denise, thank you so much for your time. We really appreciate it. And if you've got, boy, if you need landlord tenant work, where can our listeners find you?
Well, we have our traditional website, which is politically incorrect, but it's been our website for a long time. It's drevictor.com.
Okay.
I'm Holiday. Doc Holiday was the family name, so that's kind of why that was supposed to be funny. People find that offensive, so it's also H as in Holiday 3 Landlord Law. We've got great information. You don't have to use us. We've got great forms that are free on there, news articles. It really is the best place to kind of start if you're looking for a good solid lease, addendum, notices, updates on the law, all of those things.
All right. Thank you so much.
Thank you, Denise.
With that, we're going to go to, while we wait for another investor to talk with, Sean, I got another question for you.
All right.
What is the biggest pitfall investors should be cautious of when dealing with an assignment?
Assignments and pitfalls. Let's see. So, assuming you're on the assignor side of things,
Yeah, I guess it could change,
it
right?
could
Which
change,
side of the
right?
transaction?
So if I'm advising the assignor, I'm looking for to make sure that the assignment is terminated immediately upon the close of escrow date set forth in the assignment. I do not want the assignee to have any benefit from a cure notice set forth in the contract, right? So if the assignee's not going to be able to perform, I want that assignment document terminated, the rights to the contract reverting immediately, not 3 days later, not 10 days later, but immediately back to the assignor. So if the assignee can't perform, or the end buyer can't perform, the rights go to the contract, go immediately back to the assignor, and then the purchase contract should have a cure notice provision in there, which then gives the assignor an opportunity to try to, figure out how they're going to save that transaction, whether, they're going to buy it, find it another, end buyer, that type of thing. So now from an assignee's perspective, I'm wanting, I'm wanting that cure notice, right? I'm wanting the ability to take advantage of the cure notice. I want the earnest money, and I've seen this, and where the earnest money is released to the assignor. So the assignee's earnest money is released to the assignor. Seller can't perform, and then the assignee goes back to the assignor and says, "Where's my $5,000?" And the assignor's like, "I spent it." "Well, I'll get you on the next deal."
Yeah.
That's what they say. "I'll get you on." No, I don't want the next deal. I want
Yeah,
$5,000. I
no.
want my $5,000 back. The deal fell apart. I didn't buy the property.
Right.
So I want to make sure that the assignment says that the earnest money is always going to be kept on deposit with escrow and refunded if the seller can't perform. So you're going to want that in there as an assignee. So
awesome. Yeah. All right. We have another real estate investor. Thanks for joining us. Introduce yourself to our audience.
Of course. Yeah. My name's Kyle Redmond. I'm with Batch Service, and I'm here teaching people about off-market deals. So I think right now Ogie crowns it as the MLS for off-market deals. So that's what we're here to do.
Awesome. Now, you've been to the meetup before?
It's my first time. First time being here. Yeah.
Okay.
Excited.
All right.
So I know a little bit about Batch. So you do some like skip tracing and like lead services? Or?
A little bit. So basically, there's four major pillars within batch, and the first thing is property search. You have to find targeted, motivated sellers and buyers in the beginning to start. Okay. The second piece is you basically have to uncover their contact information, right? But before you do that, you have to get very niche and specific with your list. And if you don't do that, it's what we call spray and pray, where you're basically building these giant lists and you're just sending a bunch of information out to people that are probably not motivated to either sell or buy, right? So the first thing, like I said, is targeting those motivated sellers and buyers, then niching it down and creating that list, then skip tracing it and uncovering their email and their cell phone, which is key.
What about address? I was at this meetup a few months back, and there was an investor who they built their business on sending out mailers. Can you
Yep.
help an investor identify addresses of people that may be motivated to sell?
You know, that's a good question because that's the fourth pillar.
Oh, okay.
Correct.
I jumped ahead of you there. Okay,
Yeah,
I'll let
so
you finish.
you have to connect and communicate.
Yeah, right.
And,
Yeah.
and that's the last piece. So what we do is we communicate through SMS, which
Uh-huh.
is key in the game. We also communicate with direct mail. And then also we have another platform called Batch Dialer. So the best part is it's the all-in-one platform because it all talks to each other. And when a lot of people in this game, as an investor or a real estate agent, they have an issue because they have too many platforms, too many softwares. It's all over the place, right? So the data is not talking to each other. So with us, it's all in one place. You know where your direct mailer is going, you know where your SMS is going, you know where your calls are going, and it's all syncing and talking to each other back and forth. So that's key.
One of the things that my clients are always coming across and having issues with is contacting people on the do not call list.
Of course, of course.
So what kind of things do you guys do to filter that
Yeah.
information so that they don't have those types of issues?
So that's a good question. One of our main things is we want to make sure you're contacting the right number, right?
Mhm.
Because you're going to be spending a lot of marketing dollars if you're not. So we make sure that they're not on the litigator list, right? We make sure that when you're reaching out to people, it's actually their cell phone number and it's not the people that are going to sue you every single day, right? That are basically reaching out to sue you, right?
Right.
So landlines we take out, okay? Litigators we take out. So we scrub it down so it's just cell phone numbers that you're reaching out to.
Now, are you an investor as well? Do you invest, or are you just working right now with?
Yeah,
Dash?
so I work with all of our top affiliates, which are
Uh-huh.
the top people in the industry: Pace Morby, Jamil Damji,
Uh-huh.
Brent Daniels. So all these key players, I get I would say I get the opportunity to be able to work with these giants every single day and understand what they're doing and where the market's going. So that's my role in the business is just understanding just that.
Very cool. How long have you been with Batch?
I've been with them about a year now. Yeah.
Okay.
It's coming up at the end of this month. I think in like 2 days, actually, it'll be my year anniversary.
So, what would your biggest or best advice to a real estate investor be as far as data? Like, what should they be doing?
Well, I think it starts with the real estate investor. And that's where it starts because most people are actually scared to jump into tech, right? They're used to their old ways of just driving through neighborhoods, right? Trying to find that distressed property. But why not leverage technology and have it work for you, right? So the key is I think that a lot of people have this notion of not understanding tech and not really getting it right. Let's just put this as an analogy. Remember the first time you guys got an iPhone and you opened it and you tried to use it and you tried to download an app? It was hard. It was frustrating, right? You had a lot of pain inside of you. But then once you overcame it and learned how to use it, now look at your business because of it, right? So batch is exactly like that. A lot of people at first they get discouraged because it's this new thing and it's amazing, right? But they don't know how to use it or leverage it. Well, we have all the support staff in the world in order to teach you how to leverage it. Every single person that is a part of Batch actually has a customer success manager that actually holds their hand through the process. So I think the first thing is actually as an investor is taking a leap of faith and actually utilizing the tools that we provide for you. And that's key to start. I think the second piece is once you understand it is to actually be consistent with it, right? And being consistent means like picking up the phone and dialing, actually sending the SMS, actually sending the direct mail, right? And sharpening your skills at the end of the day. And that is key right there. So I mean, I think that all the greats in the industry will tell you that it's all about just taking action, right? And leveraging the tools that we have to offer.
Well, Kyle, we really appreciate you being with us. Go ahead and tell our audience one more time how they can find you at Batch and how they can get in contact with you, other than coming to this great
Yeah, of
event and
course.
networking.
Of course. Yeah, you can find us at batchservice.io and you can see all of our products on there. But I think that's the best place to start. If you guys are looking for batch leads, it's batchleads.io that we just talked about. So check us out, guys. I think you're going to like it.
Thanks so much, Kyle.
Thank
We
you.
really appreciate it.
Thank you.
All right. If you are just joining the program on the live stream, Sean and I, we are at the Scottsdale Area Association of Realtors today. We're with the Buy and Hold meet and greet. In a little bit, Sean will be giving will be giving a speech on creative finance. But in the meantime, we're meeting with investors and we're answering legal questions that that those that have an interest have. Reminder: if you can, take a moment to go to YouTube. You can find us at InRem Podcast. That's at InRem Podcast. Go ahead and subscribe, follow the channel. We really appreciate it. It helps us. We have another investor with us. Hello. Give us, introduce yourself to our audience.
Well, hello. My name is Helena Donahoe, and I represent American Title Service Agency. So we are on the title and escrow side for the investors and to help them build their business and close the transactions when they come in.
So yeah, Helena, thank you so much for coming out and actually sponsoring this event. You're like American is the main sponsor of this event, and you work with Augie and putting it on. So thank you so much for that. This is an incredible event, and I know everyone that comes out appreciates it. And it wouldn't happen but for your guys' involvement. So
we are very grateful to be here and to support the investment community. There's so many things that are happening that we want to make sure that whatever part we can provide and whatever we can help with in order to get the information out is, but we're grateful to be here.
Very cool. So tell us a little bit about the services that American Title can provide to real estate investors. Because, honestly, and I know American is, in this category, there's only a few title companies that really know how to work with investors.
Agreed.
And, as an investor, you go to the wrong title company and it does not go very well. And so tell us what American Title does for its investor clients and, why it's an investor-friendly title company.
I represent an escrow officer, and I shouldn't say an escrow officer. She is the escrow officer in the industry. Her name is Eileen Brown, and she has been in the business for over 40 years. And her expertise lies in creative finance, working with investors. If there's a transaction that they don't know how to handle or don't know how to structure, Eileen is there because she's had so much experience to help get through the process and find different ways for people to close things. We handle, again, all the closing process. My job is to handle the marketing side. So when someone is looking for a property or looking for something in a certain area where they want to be doing transactions, that's where I come in to help.
Very cool. Yeah. So you mentioned creative finance. What type of, when we talk creative finance, obviously that's my topic today, right?
Yes.
So when we talk creative finance, if somebody comes to American and they're like, hey, I'm doing a seller carryback, you guys can put together the promissory note and the deed of trust and, set up. Do you guys do any of the servicing, like loan servicing, or?
We do not. We actually have two companies that we use that are our partners to handle the account servicing. So if we're doing a subject to, if we have, any type of creative that we're doing that requires account servicing, we have two companies that we work directly with. And because of Eileen's background, she's been doing it for so many years that if we see something, and that's one thing I wanted to mention, if we see something on a transaction that doesn't make sense or doesn't look right, we're going to let you know.
Mm.
If we see something that, perhaps, we have additional information that we can give you as far as structure, we can give you the tools that you would need. We can't structure it for you because we are in the middle, we're Switzerland.
Right.
So, but we can give you the tools that you need. So that's usually what I let everyone know is if you have a question on creative finance, Eileen is the person to call. She's done it all.
Mhm.
She truly has done it all.
And you said like 30 years in the industry?
Yeah.
Something like
Well,
that?
40.
40.
I'm going to say
Oh,
it on
man.
camera. It's recorded for all time and eternity. It's been like
Ama-
we're over 40 years. Yes, I'm not allowed to say exactly how many,
Oh,
but yes,
wow.
she's been around for a very long
That's
time.
incredible. Yeah.
And with our company, we're there to help,
Mhm.
and we stand by our above all else service, and that is American Title. If you have a transaction that's not with us, we'll still help. Someone had a situation with the title company on Facebook the other day, and I just private messaged them and let them know this is what we do. We're not asking you to move the transaction, but we can help you, or we can contact the escrow professional and collaborate with them to teach them how to do your transaction to get you through it. Because a lot of title companies don't understand how the process works.
And that brings up a good topic, because I'm asked all the time, and I feel bad when I don't have it. Sometimes I do. I have the referral. Do you guys have the ability to or have referrals for title companies that are out of state that are investor friendly?
We do. We have a network of individuals that we work with. Because American Title is independently owned and operated, and we're one of the largest in Maricopa County, our focus is in Arizona, but we do have outside partners, and I work with several other investor groups and multifamily syndication. So we have people all over the country that we can refer to that understand the process.
So if somebody's looking for a investor friendly title company in Nevada, for example, they can contact you.
And if we
and
have that in our network, we can absolutely
Perfect.
refer them over.
Awesome.
And
That's
if we
great.
don't have someone, we can find someone for you.
Oh, that's that's
Happy
really
to
good to know. Well, that's what this is about, right? I mean, that like tonight, that's what it's about is helping each other and being resources for each other. And
Yes.
it really is amazing how the investor community is like that. You would think because it seems competitive, right? But no, everyone's trying to collaborate and joint venture and was it squat up or
Squat up, yes,
squat
that's
up?
the other one. But yes,
And-
it's definitely collaboration
Yeah.
over competition because we want
Right.
everyone to succeed, and we're all heading for the same finish line.
Yeah,
And if we can help each other get there, why wouldn't we help
right.
each other?
Exactly. Yeah, very cool.
So we're at the Arizona Buy and Hold Real Estate Investor Meetup, and it would have been an awesome opportunity to meet you by coming here. But for the folks that didn't make it, who are thinking about coming in the future, or who can't, how can they find you? New real estate investors or seasoned real estate investors that are looking for a great title company that knows and understands real estate investors. How can they find you?
We are located on two separate pages for Facebook, which you can go to our American Title Service Agency, Norterra, which is where Eileen is located at, or American Title Service Agency. And under my personal name, Helena Donahoe, anyone can reach me through there and always send a message anytime. And my email, should
Go for it.
Yeah. Yeah.
if you would like to reach out by email, it's hdonahoe@atsaaz.com. And we're happy to help in any way we can.
Well, Helena, thank you so much for being
Thank you.
here. We appreciate it. Keep her in mind. There's nothing more important, I can say as an attorney, but I know for real estate investors to have a title company that understands them
Great.
and knows that process. So thanks so much for joining us.
Thank you.
If you're just joining us again, we are at the Arizona Buy and Hold Real Estate Investor Meetup that's taking place at Scottsdale Area Association of Realtors. They do this every month. It's a great time to not just learn, but meet other investors, other companies that are within the market that can help facilitate you as an investor. So make sure if you're watching now, think about the event in the future. It's a great opportunity. We have another investor to meet. Thank you for joining us. Introduce yourself to our listeners.
I'm Jeff Mongold with Axia Home Loans.
Jeff, tell us about you and your company.
We do mortgages,
Okay.
residential only. We don't do commercial or land loans or construction loans. I've been doing it 2 years, real estate for 4 years prior to that. Prior to that, I spent 17 years in law enforcement.
Okay, so you've seen a little bit of everything.
A little bit of everything, yes.
So tell us, as far as Axia Home Loans, obviously you're here at a real estate investor event.
Yep.
And so how can real estate investors work with you and on the lending side of things?
So just a couple quick things about Axia. Actually, we're an ESOP, so we're an employee-owned company, 100% debt-free with reserves, so we don't have to worry. If you do come with us, you're definitely secured. So investors, we do 203K loans. We also do investment property loans, second homes, anything else like that that you may need.
Very cool.
What brings you? What do you enjoy about that? Is this your first time at the meetup, or are you a regular at
It's
the
my
Buy and
first
Hold?
time at the
Okay,
meetup.
all right. What brought you here originally?
Our office is upstairs. They asked us if we would be interested in talking to some people. So
How long have you been in the business of lending?
2 years.
2 years.
So you're located here in the building.
Yes.
Well, that's a good spot to be, right? The association. Yeah. Very cool. And do you guys regularly work with like real estate investors, in working with, their transactions and stuff like that?
I have about 3
Okay.
investors that I work with.
Yeah.
So right now, a lot of the investors are looking at having the sellers buy down points.
Hmm.
Okay. I've had some great success with agents asking for concessions to get the points down, make the home more affordable. It actually works in the favor, instead of a price reduction, works for the seller and the buyer.
Mhm.
Seller's not taking as huge of hit if they take a price reduction of, let's say, 50,000, or they buy 20,000 in points. Both are walking away happy. So it's been really popular lately.
So obviously the market's shifted.
Yes.
So what has that meant for you and your company?
Well, at first there was a pretty good slowdown. People were nervous. People are starting to come around, starting to realize, hey, look, the rates are going to continue to go up. They're starting to realize that it's going to be the norm for a little while, the increase in rates.
Jeff, let me ask you, and don't be afraid to get in closer to these mics. With the noise in the background, the mics like to drown out unless you're close. As a lender, given kind of the economic market that we're in, and with a rising interest rate, so on and so forth, is there a set of things or one thing if you could communicate to investors, either to be prepared for or things that would be helpful, what should they be prepared for given what's going on?
Well, I think the rates are going to go up a little bit more. Okay. I mean, it's volatile right now. The market's very volatile when it comes to rates. I think it's one of those things: you invest, you ride it out. Buy the house you want now, invest in the property you want now. If you're not doing cash, refinance down the road. Rental properties are huge right now. So, it's a win-win.
Tell our listeners where they can find you, the ones that are watching, other than coming to this event and meeting you, which is a great option and opportunity, and hope you'll be here in the future for that. How can the listeners find you?
So they can find me at axiahomeloans.com/Jeff Mongold. Last name is Mongold.
All right, Jeff, thanks so much for being with us. We appreciate it and enjoyed
Appreciate it.
learning more about your business. All right, with that, if you are, again, just joining us, we are at the Arizona Buy and Hold Real Estate Investor Meetup. If you're watching the live stream, take a minute, head over to our YouTube channel. It is at InRem Podcast. That's at InRem, REM Podcast. Go on there and subscribe. We would really appreciate that. We have a few minutes, and we're going to be live streaming. Your speech. Why don't you give everybody listening, Sean, just kind of a synopsis of what why they ought to be sticking around?
Yeah. So what I'm going to be talking on is legal issues involving creative finance. So I'm going to be going over the different types of structures that exist on the property itself. So is the property owned free and clear, or are there loans against the property? And then we'll be talking about what that looks like, depending on the nature of the property and the loans against the property. We'll be talking about the different transaction structures themselves, or the way that we can put together a creative finance transaction. And then we're going to talk about the documents that you need for each different type of creative finance transaction, as well as the terms that you're going to want in those documents. So it's going to be fairly comprehensive, going over, almost you could leave here with a checklist of documents that you need to do each and every creative finance transaction.
We've got just a couple more minutes. Want to leave time for any other questions that we have. And I have a question here, and I'll pose to you, Sean. I'm selling my home, and the buyer just backed out of the deal. Can I force them to buy the property? What say you?
The buyer backed out?
The buyer has backed out.
Oh, depends what state you're in. As we learned on our show a while back with our law partner, Brian Locker, who's also licensed in Georgia, he informed us that you could seek specific performance of a buyer in Georgia. But here in Arizona, specific performance isn't available for a buyer. You can't force a buyer to perform. So what you're looking at is damages. There's two ways to establish your damages. One would be, I had it under contract for, and you agreed to buy it for, say, 500,000. You bailed. The property's gone down in value, and now I can only sell it for 100,000. So that would be your damages. But, and here's the key thing: you can only pursue those damages if you do not retain the earnest money. But if your contract says that the seller may retain the earnest money, or shall retain the earnest money as their sole remedy or their sole right to damages, then you keep the earnest money, and that could be your sole remedy. So it really depends what you do. But if you have the earnest money on deposit, you keep it on deposit, or you refund it to the buyer because your damages are greater, and you don't have a limitation in your contract saying that's your sole remedy, then you could pursue for damages if, let's say you can't sell the property for the same amount that the buyer would be purchasing it for.
Versus on the flip side, if the seller backs out, then there is the legal remedy of specific performance, right?
Correct. Yes.
Okay.
Yeah.
All right. Thank you. With that is we're reaching the 5:00 hour. That is our backstage live prior to the Buy and Hold Meetup event. What we're going to go ahead and do is we're going to keep the live feed going with a thumbnail there while we transition and go to the speech. So stick with us, stick with the live stream, and that is going to begin shortly. We appreciate you joining us. And we will see you on the other side of the intermission. So
Yeah, we'll be back in about 10, 15 minutes.
All right. We'll see you guys soon.
Mm. You're getting there. Can you hear me? Can you hear me? Can you hear me? Thank you, Sean. Hey, everybody, thank you for coming for the event for Buy and Hold Investors Meetup. And I really want to thank you, our sponsors, American Title, and the loan doctor, Rafael. He's not here in the room, but still be coming. And of course, everybody knows that mortgage rates are skyrocketing. So, what a good opportunity to learn more about creative financing and taking over existing mortgages that have 3.5% interest rate. And everybody's talking about subject to and wraps and all kind of these creative financing deals, and they sound really easy. And I thought the same thing. However, when I sat down with Sean and I asked him to create for our company the full set of legal documents for our subject to deals, I was very surprised when he came back with about 12 different documents. It was crazy. I was like, oh my God, okay, now you have to come and speak at the meeting so everybody knows what exactly they're dealing with and avoid legal issues when dealing with subject to and wraps. So please welcome Sean, and he's going to be talking about creative financing today.
All right, thank you, Audrey. All right, thank you, everyone. I am going to, the room's small enough, so I'm going to take off this mic because, as you can see, we're live streaming the show, and so because we're live streaming with the microphone, we're getting an echo there on the live stream, and it's going through the Buy and Hold Facebook page. So we hope you all come out on a regular basis to support the event, but if for some reason you can't make it, feel free to join the live stream. We're going to hopefully be doing this on a more regular basis. So yeah, so today's topic will be creative financing, and part of that includes subject to, and so we'll talk about that in a minute here. But basically, when we're talking creative financing, we have to basically decide, okay, or figure out what's the status of the property. Is the property owned free and clear? Which you can still do creative financing on a free and clear property, it just looks a little bit different. Or are there loans against the property, and are you going to be taking it subject to the loans, or a sub to? Is it going to be that type of transaction? And that requires the set of documents that Augie referred to, because when you do subject to, there's a lot more documentation, a lot more disclosures, a lot more authority that you're going to want in dealing with the loans on the property. You're going to want to receive or be assigned insurance proceeds, those types of things. And so we'll talk about what those documents look like. So when you're talking creative finance, you need to figure out, okay, what's the status of the property? Is it owned free and clear, or am I going to take it subject to the existing loans? Then once you figure that out, there's three basic structures. And it doesn't matter whether it's owned free and clear or you're taking it subject to. These are the different ways that you can creatively purchase a property or use creative financing to purchase a property. The first one is a warranty deed with a seller carryback. So you're going to buy the property and the seller is going to carry back a loan. Second is an agreement for sale, or some states call it a contract for deed. So in Arizona, we call it an agreement for sale. And in an agreement for sale scenario, the title to the property doesn't convey. Instead, the purchaser is given an equitable interest along with a possessory interest in the property, and then they make payments according to the agreement for sale. They can make the payments monthly, quarterly, annually, or they could even have a balloon payment where they make the payment at the very end of the transaction in some amount. And so, you know, any way you can think of as far as structuring the payments, setting up the payments, as creative as you want to be, you can be that with the agreement for sale. And so you can figure out, okay, what makes sense as far as the payments that I'm going to make in order to purchase this property. And then finally, it's a lease with option to purchase. So that's really the third way of purchasing property creatively. There are other ways. They're way, more high level, such as using membership interests in LLCs and trusts and things like that. I'm not going to go over that today. That would be, almost a one-day class on how to do that. But what we're talking about today is more of just the basic creative financing structures. So the first one is your straight up purchase, right? You're going to use a warranty deed and the property's free and clear. So what kind of documents do you need if you're going to do this type of transaction? So you're going to do seller carryback with a property that's free and clear. So the first one is you need a purchase contract that's going to contain all of the terms of the seller financing, right? You want the basic terms of the seller financing, and you want to make sure that you have all those terms, because what you don't want to do is get to the closing table and the seller's like, oh, well, I didn't agree to those terms when they're presented with the promissory note and deed of trust. No, I'm not accepting those terms. Well, no, you accepted them in the purchase contract, but if you don't have them in there, then do you really have a way to enforce your purchase contract? So you want to make sure that you have the main substantive terms, right? The principal balance of the loan, the interest rate, the payment amounts, balloon payment, maturity, those types of terms is what you're looking to make sure that you're going to have in that purchase contract, and it's going to be documented there. Then the next is a promissory note, right? You're going to execute a promissory note in favor of the seller, and that is your evidence of the loan. So the seller's making you a loan. Basically, they're selling you property and not requiring you to pay up front. So that's the loan. And then the promissory note is evidence of that loan. It's evidence of that debt. And so the promissory note sets forth the payment terms on that loan. And so the purchaser, the buyer, is going to execute that promissory note as the maker, and they're going to deliver it to the seller as the lender or holder of that note. And then finally, in Arizona, we're a deed of trust state. If you're outside of Arizona, you would use a mortgage, or in a state that has mortgages versus deeds of trust. But in Arizona, we would use a deed of trust. And so that is the lien. That is what secures the repayment obligations. And so the deed of trust would be executed as on behalf of the purchaser as trustor, and they are then putting that document in the hands of a trustee who will be appointed, and the trustees are either a real estate broker, a title company, or an attorney. And so you identify a trustee on there who can serve in that capacity, and then the lender, the seller in this case, will be the beneficiary of that deed of trust. And if the purchaser doesn't pay as agreed, then the seller can start a foreclosure and or cause the trustee to start a foreclosure and sell the property on the 91st day after a notice of trustee sale is recorded, and either take back the property or sell it to a third party and end up with their purchase price, doing it that way. So those are the documents, 3 documents. If the property is owned free and clear, and you're going to do, basic, I'm going to purchase it outright, warranty deed, have fee simple title, and subject to a deed of trust and seller carryback. Those are the 3 documents you need. What about purchasing it subject to? Now this is where it gets more complicated. This is where you have those documents that Augie was talking about. So the first thing you need is a purchase contract with the proper terms. Proper terms would be, and we'll talk about those in a little bit more detail, but they would contain the terms of the seller financing as well as some other terms which we'll get into and you're going to want to know about here in a minute. You need a subject to addendum. So this is going to have disclosures and require that the seller sign certain documents at the closing table. You need an authorization to release information as to the existing loans and insurance. So you want to have the ability, because remember, you're taking it subject to a loan out there. You are not the borrower on that loan. So you want to make sure that if you place a phone call to the lender to find out how much is my payment or how much is the payment, why hasn't the payment been applied? Where did how much is the insurance that I'm supposed to pay every month? How much are the taxes? And you just need information from that lender. You want to be able to receive that and be able to figure out what's going on with the loan that you are now required to pay. And so you're going to want an authorization. You're going to want an assignment of insurance proceeds. So most lenders are going to require, there's a whole, as far as there's a number of strategies that you can employ with insurance, but there may be a period of time where the only insurance against the property is the insurance that's procured by the seller and delivered to the lender and paid as part of the monthly payment made to the lender, right? And so a lot of times you're going to want to keep that in place so that the lender's comfortable and feels good with what they have. Well, if the property burns down who's the insured? Well, the lender gets paid first, and then the seller is paid second, and you, as the new owner of the property, receive nothing because you're not an insured under the policy. So you want to make sure that you have them execute an assignment of insurance proceeds that basically states, hey, to the extent I'm going to receive any proceeds on this property, it goes to you, the buyer, because you've now taken over this property, and you're going to receive those funds. So you want an assignment of insurance proceeds. You want an instruction letter to the lender as to the application of escrow funds. So I mentioned before that you're paying, as generally as part of the mortgage payment, you're paying an amount for taxes and insurance. And because you're paying an amount for taxes and insurance, in that case, they pay ahead. You don't pay from behind. And so they always are running a positive balance. So what happens when you've paid on this loan for 5 years and you're ready to pay it off, and you pay it off, and now $5,000 is sitting there, or $2,500 is sitting there on deposit with the lender? Well, they're going to send that either A, back to the original borrower, even though you're the one that paid it, or B, they're just going to hold it. And so what you're going to want to do is have an instruction letter that says, hey, I'm the borrower. Hey, lender, if there's going to be a payoff, refund it to this party, or apply it to the payoff. That way your payoff is now $2,500 less by applying it to the payoff. So you're going to want that instruction letter. And then you're going to want a limited power of attorney for purposes of insurance, mortgage payments, escrow, and any other matters related to the property. So you're going to want to make sure that you can act on the seller's behalf with respect to the property as to these areas that you may have to step in and work with professionals, title companies, others with respect to the property. And you don't want them holding you up because they say, well, you're not the borrower, or you're not the insured, or you're not this, or you're not that. You say, well, I am their agent in fact, and I can act on their behalf with respect to this property and this transaction. And then finally, you're going to have a promissory note and deed of trust in favor of the seller. So those documents are the same as though the property were owned free and clear. You're going to have your promissory note and deed of trust in favor of the seller. All right, let's talk about the terms of a purchase contract for a subject to transaction. So one would be, you're going to include the purchase price, which is basically all loans against the property, any reinstatement amounts, and other amounts to be paid to or on behalf of the buyer. Now, granted, you're not coming out of pocket for those loans, but you're agreeing to pay the loans, right? And so the reason why you want the purchase price to include basically as much as possible that you're going to be paying is for your basis, right? Because hopefully you're going to sell the property at some future time for a profit. And if you bought it for an investment, then there's capital gains and other, tax consequences potentially. So you want to make sure that that basis is nice and high and documents and includes everything that you're putting forward to purchase the property. You want a limit on a restatement amount. So if you are going to reinstate, let's say, you have a seller that's in distress, they're behind on their loans, and you say, okay, I'm going to come forward and I'm going to make the payment. And you're sitting there and you say, how much do you owe? Oh, $5,000. Well, you all know that $5,000 is more like $25,000, right? It's never $5,000. It's going to be substantially higher. And so you say, oh, and you put in the purchase contract, I'm going to reinstate your loans. And then you get the $25,000. You're like, wait a minute. And the seller's like, well, that's what you said you're going to do. And you're like, yeah, because you told me $5,000. Well, it's not in the contract. It says you're going to reinstate. So, show me the money. Now, you want to put a limit saying, I'm going to, a buyer's going to reinstate the loan in a maximum amount of, and then you put an amount down, the maximum that you're willing to do in that scenario. The terms of the seller financing, same concept, right? But instead of, like I discussed before, where you're going to put in, unless there's equity and you're going to pay the seller and you're going to do a hybrid wrap where a portion of the payments go towards the loan and then a portion goes to the seller because you're also paying them out on their equity. But if it's straight up a mere loan transaction, unlike a property owned free and clear, you're not going to specify in detail like the principal balance or the principal balance, interest, maturity date, blah, 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 blah. You're going to simply say that the financing terms are going to mirror and be identical to and be in the same, principal balance as the loan, and then describe the loan. And so it's going to be a mirror financing transaction. So you're going to want those terms to mirror each other. You're going to want state required disclosures. Now, this is a buy and hold meetup, so I'm assuming that you're going to do the creative financing for a buy and hold, but let's say that you are going to assign this transaction. Well, now in Arizona, if you are going to do an assignment of this purchase contract, once you have it locked down, you have to disclose that you as the buyer are a wholesale buyer. It's a new state regulation that's effective September 1st. And if you don't, then the seller can back out at no risk. And they, in fact, not only no risk, they get to keep the earnest money. So you want to make sure that if you are going to do an assignment of this transaction, or that's even a possibility, you're going to want to disclose that the buyer is a wholesale buyer.
When did that law go into effect?
September 1st. So it was passed a number of months ago, but as in most laws that are passed by our legislature and signed by our governor, there's always a future effective date so that people can kind of prepare and get ready for it. So September 1st was the date that it went in effect. All right, then you're going to want a subject to addendum. And what's the subject to addendum going to contain? It's going to contain disclosures by both the buyer to both the buyer and the seller, right? So you as the buyer, like, why do I need disclosures? Well, first, if you're buying and hold and do, if your goal is to buy and hold, you may not need the disclosures. But if your goal is to assign the purchase contract, you want those disclosures because you want to make sure that the assignee or the end buyer fully appreciates and understand the type of transaction that they're taking on, right? And so many of those disclosures involve the due on sale clause, right? That, hey, this transaction may invoke the due on sale clause, or the lender has a right once this transaction is done to invoke the due on sale clause. Here's what may happen. Here's the potential consequences of it. Here's what we can do should that happen. Here's the performance that we're gonna make to fix the scenario, whatever the case may be, right? You're gonna want that in your subject to addendum, basically outlining what happens in the event of a due on sale, disclosing that the due on sale is a possibility, disclosing to the seller, hey, look, this loan is going to remain on your credit for at least some period of time. And if they pull a credit report and they're looking at debt to income ratio, you're still going to be shown as a borrower here on this loan. If there's late payments on this thing, you could end up with damage to your credit. All of those things should be disclosed to the seller so that they fully appreciate, hey, the nature and the risks of the transaction that they're entering into. You also want an agreement of the seller to execute all of the different documents we already went through at closing, right? You're not going to, generally at the kitchen table, and some of these, like assignments and stuff, you may want notarized. You're not going to, at the kitchen table, have them sign an assignment of insurance proceeds, an authorization to release information potentially. Maybe you will, but you're not going to have them sign a lot of the documents that I already listed out here that you're going to want. So the subject to addendum says, hey, look, seller, you're going to be presented with these documents at the closing table and you will be executing them. That way you have the seller's commitment that these are the documents that you're going to execute at the closing table, seller, to effectuate this transaction. And you're also going to want a future cooperation clause. All right. So an example would be the mortgage payment goes up. And the reason why the mortgage payment goes up is because taxes have increased or the cost of insurance has increased. And so now the lender's like, hey, you owe an extra $100 every month. So you want to make sure that the seller's cooperating and disclosing that type of information to you. So if the seller receives a notice from the servicer saying, hey, it's an increase of $100, well, in that case, you want the seller to have future cooperation. You want the seller to provide that information. If you have an issue with the lender and you need information, you want to be able to contact the seller and say, hey, seller, the lender's not working with me. I need you under this cooperation clause where you've agreed to cooperate. I need you to contact the lender and get this information for me so I can make the payment, or I can bring the loan current, or whatever the case may be. So you want to make sure you're locking the seller down to future cooperation, and you want it to be broad. You want them to have significant duties and obligations to cooperate, to disclose information, to keep you current on what's happening on the loan if for some reason you're not able to receive that information. All right, promissory note and deed of trust. So that's also what you're going to want. Now, these provisions may be the same whether or not the property is owned free and clear, you're buying it subject to. So a couple of interesting clauses, and I always require, at least my clients, to make sure the seller initials right below these clauses, and they're highlighted and they're bold, because we want the seller to know that they exist. So the first one is the right of first refusal. So when I described the promissory note, I described the lender as being the holder, right? Because the lender, the seller, holds the paper. Well, a promissory note is a negotiable instrument. And as a negotiable instrument, it can be transferred at any point. So if the seller, especially on a free and clear property, let's say they negotiated 5% interest and they need some cash, and somebody's like, well, I wouldn't mind taking your note. Is this person paying? Yeah, they paid great for the last 2 years. Hey, I'll pay you X amount of dollars and I'll take your note from you, right? And so they're going to buy the note from that seller because the seller needs the cash. And so the seller's going to sell the note, which is well within their right of holding a negotiable instrument. They're going to sell it. And now you're making payments to somebody else. Well, they may have sold it for 80 cents on the dollar. Well, you want that opportunity, right? You would like to buy that note for 80 cents on the dollar. So you want a right of first refusal saying, hey, look, seller, if there comes a point where you want to transfer this note to somebody else, I have the right of first refusal. You have to offer it to me for whatever price that is. And so you then have the right to come in and purchase it for, say, 80 cents on the dollar, whatever amount they're going to convey it for. The next is substitution of collateral. And so what this means is, hey, we're putting a loan against your property right now, or a lien against your property right now. But there may come a time where I have a property with just as much equity that's just as good as this property that I can give you a lien against to release or free up the lien against this property. More sophisticated investors, they have the strategies on why they would want to do that, and the situations in which they would want to pull that off. But basically, let's say they want to sell this property, or they want to refinance on this particular property. But of course, they want to move the loan over to another property. They can substitute collateral. Seller's still protected. They still have the same amount of, protection and equity as when the loan was first made. But you're substituting collateral. You're removing the lien from this property, putting it on the other property. And then finally, no due on sale clause. You do not want a due on sale clause. You want to be able to convey your interest in that property subject to the seller carryback, right? So you want to be freely able to do your own subject to transaction to somebody else if that's what you choose to do, without worrying about the seller coming out of the woodwork and calling the loan due. Once again, those are provisions that you want to, if you've negotiated them with the seller, like, don't just slip them in a note. You can't do that. You should not do that. What you're going to want to do is negotiate with the seller and say, hey, this is what I propose. This is what these clauses are. You're going to find them in there. You highlight them. You have the seller initial them, so that if there's ever a question, you can say, look, it's normally I just sign the note. Normally I just sign the deed of trust, but we had you come in. We had you agree to these terms. We had you initial, showing that you were agreeable to these terms, and these were part of the transaction that we entered into. Of these three, probably the most important in my view, especially if the property is owned free and clear and you're doing just a straight up seller carryback, is the no due on sale clause. I would always recommend trying to talk to the seller about that, putting that in there, let the seller, initial. They haven't really lost any security. I mean, their deed of trust is still out there. And if the new buyer or the new owner doesn't pay, They can just foreclose like they could with you as the buyer, and they're really not, not likely checking your credit and doing, a background like a conventional lender would. So there's less onus on having a due on sale clause in the note and deed of trust.
Do you have terms on that then of what they can do? So for instance, if in that exact circumstance, you have you're purchasing the property and then you're essentially wanting to sell it or almost to sign it in a way to somebody else, do you have restrictions as to how you can sell it, or can you just pass it on to any Joe Schmo who says, I want to buy this house?
So the question is, are there any restrictions on selling it if you negotiate a no due on sale clause? No, there are none. So you could sell the property subject to the seller carryback at that point, and you sell it to somebody else, and then they're responsible for paying the loan. You can structure the transaction similar to what we structured, how we've discussed structuring it here, but instead you're the seller that's selling it, on a subject to basis, with the prior seller financing still out there. So yeah, you can sell it in that case, and there's no restrictions because there's no due on sale clause. Now, the original seller is still protected because they still have a lien against that property. So if they decide, hey, look, payments aren't being made, so I'm going to go out and foreclose. I'm going to take the property back, or I'm going to sell it to a third party via a trustee sale and get my money back that way. So they're still protected. The only difference is the loan payments aren't coming from the original buyer, they're coming from the new buyer. Yeah. Yes.
So if you're a buyer, you want no due on sale clause, but if you're a seller, you prefer not to have that.
If you're a seller, you may want a due on sale clause, or you may not. I mean, if you're selling it, and that's a sticking point on the transaction, and it's an otherwise good transaction, and you're taking a lien against the property, a deed of trust, and if the person you're selling it to, or whoever they subsequently assign or sell it to, doesn't pay you, and you can foreclose, then maybe you're fine with that.
But
Yeah.
Foreclosure is a little bit long drawn out process versus
90 days.
You know this buyer versus if you're a seller, you know this buyer.
Yeah.
But then if that buyer's, sells it to somebody else, you don't know who you're going to deal with. So
Yeah.
if I'm a seller, I don't want that due. I want a due on sale clause.
Okay, and that's what you negotiate, right? If you're the seller, and you're uncomfortable with a subsequent buyer conveying the property, then yeah, you can negotiate and make sure that due on sale clause gets in there. Tristan, hey, how are you doing?
Sorry, Ryan. Oh, yeah, you're right. My question was just like, is there a performance fee that would go in place of the foreclosure? Maybe they could sign like something that says they don't need to go through the foreclosure proceedings because you have a performance.
Correct. So the question is, what about a performance deed? Would that solve a seller's concerns? I as the seller would not want a performance deed. And the reason why I would not want a performance deed is because Arizona law provides two statutory means for either causing a forfeiture or foreclosing on property. One of those is through a deed of trust and a foreclosure sale through the deed of trust, which provides for a 90-day period. The second is an agreement for sale, which allows for a non-judicial forfeiture by notice under certain circumstances, and the timeframes are dictated by what's been paid. So if I'm the seller and I say, hey, look, I want you to execute in favor of me a deed in lieu of foreclosure, and I'm going to keep that in trust, and the minute you don't make a payment, I'm going to go and record that and take the property back. To me, that's not going to work, because if a buyer comes forward and says, hey, wait a minute, you did an in run around our statutory procedures, which have built-in time periods, and there's no mechanism for dictating when you can record that, performance deed or that deed in lieu of foreclosure, then I don't feel protected, because I think a buyer could challenge that at any point. Now, if I'm a buyer and the seller says, I need a performance deed to make this transaction happen, I might be willing to give them the performance deed, because the only party that can object to the performance deed is me as the buyer. And so if I'm like, well, if that's what the seller needs to make this transaction go, and I feel comfortable that I'm going to make all the payments, I'll deliver the performance deed, because the only party that can object is me, and I'm not going to object because that's what I negotiated. But if I'm the seller and it's reversed, then I know the buyer can object, and now I'm putting myself at risk because there's no statutory mechanism for the timing and time frame for me to record that deed in lieu of foreclosure if it was executed prior to the start of a foreclosure process or proceeding. Tristan, yeah, question?
I was going to ask, I think I lost a little bit of track, but it was really on the difference. When it was the sale clause. If I were to get a house under contract subject to, or seller finance, whichever it would be, with a seller finance note in place, we had no due on sale clause with them, but we were conveying it either on a wrap with a due on sale clause so that we could prevent them reselling it, so we could have that first right of refusal on not just the note, but also the sale of the property, that we had first right of refusal to buy the property back. I know that certain people, they've been projecting these options so that when it comes to a point they execute on that, then they project the growth. Similarly, on a wrap, they may be hoping that the value goes up, but with higher interest rates, it's less likely that they're going to have the equity to be able to pay it back. So effectively, you're probably bringing cash to close to wipe out that deed, but that's reducing the chance that they're going to sell to somebody else. You get the property back with some equity in it after you wipe out that deed.
Right.
So you can convey it, but the buyer,
sure,
you can't convey it.
Yeah. So you basically, those are two separate transactions with terms that are negotiated between the parties. So if you want to and are able to negotiate a purchase with no due on sale clause, but then when you go to disposition, you negotiate a due on sale clause, that's two separate transactions, and that can be negotiated. Yeah. All right, so let's talk about dispositions of property purchased via warranty deed and seller carryback. So this type of transaction, this type of creative financing gives you basically the greatest opportunity for doing dispositions. So there's basically 4 different ways that you can do dispositions of this. There's actually more, but I won't get in there with LLC membership interests and trusts and things like that. But these 4 are the basic disposition methods that you can use in this type of creative finance transaction. So it's an outright sell to a third party. So you find a third party, they're willing to pay more than the loan amounts that are outstanding, or more than what you paid, and you go and you sell it to a third party. You can do that, or you could sell it to a third party with seller carryback financing. So you could be the lender and sell it. There are some restrictions on that with Dodd-Frank and the SAFE Act, as far as the ability of an investor to do so many a year in a 12-month period. If, and here are the requirements, if you're conveying the property to an individual as opposed to an LLC or a corporation. So if you're conveying the property to an individual who intends to reside in the property, Dodd-Frank kicks in, and there are certain restrictions on the number of transactions that you can do a year. Now, there is pending in Congress some legislation that is going to change that and dramatically increase that amount per year up to like 25. So let's hope that goes through. But right now it's limited to 3 per year that you can do under Dodd-Frank to individuals who are going to or plan to reside in the property. And when you do those transactions, you have to verify their ability or take reasonable steps to verify their ability to pay, and the loan has to be fully amortizing, which means, you know, it has to be, you can say 5 years, but the payments have to be amortized over 5 years or, you know, 30 years, those types of things. So there's a lot of restrictions with Dodd-Frank, but keep that in mind. Now, if you're going to convey it to an LLC, that's fine. You know, all bets are off. If you're going to convey it to a corporation, that's fine. You can do seller carryback. But to an individual intending to reside in the property, you need to follow Dodd-Frank and the SAFE Act. You can also do an agreement for sale, once again, subject to Dodd-Frank and the SAFE Act. So you could do your own agreement for sale. So you go in and you purchase the property using seller carryback, and then you find a buyer, and instead of doing a traditional seller carryback, you do an agreement for sale. And as you'll see, it's actually a simpler process. It's one document, an agreement for sale. There's, you know, not a note, deed of trust, any of that. And you do the agreement for sale, and the ability to cause a forfeiture early on is a lot quicker and easier than, say, foreclosure under a deed of trust. So there's some advantages there with the deed of sale. And then finally, you could do a lease with an option to purchase. And so lease with option to purchase. Make sure, though, that they're two separate freestanding documents. One is a lease that doesn't reference the option. The second document will be an option to purchase that does reference the lease as being a lease in performance, and that so long as the lease is in existence and there's no breach and no eviction, the option's still valid. But the minute there's a breach and an eviction, the option goes away. So the option can reference the lease should not reference the option. The lease should be a freestanding document. Payments under the lease should not be applied to the option, because what happens if you do it that way, in fact, we were talking to Denise Holliday about this very issue a little earlier today. And as she explained, what happens is you go into court, and the minute the justice of the peace sees the fact that a portion of the rental payments were being made towards an option to purchase, they throw up their hands and say, there's a property interest. I don't have the ability to determine a property interest. I only have the ability to determine possession. Case dismissed, go to Superior Court and figure it out. And now you're significantly delayed in your eviction process. So you're going to want a separate lease with an option to purchase that then references the lease as being a lease in performance, and a breach of the lease will constitute a breach of the option and termination of the option. All right, documents for an agreement for sale of property owned free and clear. So let's say you decide, well, I'm not going to do seller carryback. I'm just going to do an agreement for sale for various reasons. Agreements for sale are actually easier to close outside of escrow. And so maybe you want to just close outside of escrow for one reason or the other. Now, I do recommend that you, at a minimum, get a title commitment. You could also obtain title insurance at some subsequent date. You can obtain title insurance for the conveyance of the warranty deed. But if you're going to close out of escrow, know that, you know, there are risks associated with doing so, the lack of title insurance, but an agreement for sale allows for that, because the only document you need for agreement for sale is an agreement for sale, right? There's no purchase contract, there's no promissory note, there's no deed of trust. It's just an agreement for sale, and that's the only document you need to be executed to effectuate this transaction. All right. I got a typo. Let's pretend that this says subject to. Let's pretend that this section says subject to. So documents for an agreement for sale of property that you're taking subject to. So we'll pretend that that's what this slide says. So the first thing that you're going to want is you're going to want an agreement for sale. The second thing you're going to want is a subject to addendum, because an agreement for sale can give the lender the ability to enforce the due on sale clause. And so because the agreement for sale is a recorded document, and so because it's recorded, and it shows an equitable conveyance of interest, then at that point, there is the opportunity for the lender to step up and force their due on sale clause. Once again, it's basically the same documents that you need for taking a property via warranty deed, subject to your authorizations, your assignment of insurance proceeds, your instruction letter, your limited power of attorney. So those are the documents you need for an agreement for sale subject to. Now let's talk about what are you going to want in your agreement for sale, regardless of whether it's owned free and clear or it's owned, you're taking it subject to. Now, what an agreement for sale provides, and in case I didn't cover it well enough early on, it's basically saying I am going to pay you over time, and when I finish paying you, you're going to give me a warranty deed that I'm going to record, and then I'm going to have title to the property at that point. But I don't have title up to that point. I have an equitable interest and a possessory interest. So I have the right to possess the property, and I have a right to complete the purchase of the property, but that's what I have. I don't have fee title ownership of the property because the warranty deed still is in the name of the seller. So the first is the terms of the seller financing. So agreements for sale, you can pay the seller interest, and you can dictate what those interest terms are. You say what the monthly payments are, etc. So you maturity date, balloon payment, all of that will be in the agreement for sale. Now, if you're taking it subject to, then and all you're going to be doing is paying the existing loan payments, then you're going to say that the financing terms are going to mirror and be identical to the existing loan, and then you define what loan it is that you're going to be paying. Next is an account servicing agent. So this is an interesting but important concept of an agreement for sale, and has significant consequences depending on your choice. So I recommend always having a servicing agent. So someone who collects the payments and then disperses the payments according to the agreement of the parties. So if you're doing a mirror loan, then it'll say that you're going to pay this account servicing agent. The account servicing agent is going to take the appropriate portion of the payments, and they're going to write a check to the existing lender. The significance of having an account servicing agent for an agreement for sale is that it is necessary in order to do a forfeiture. So in the agreement for sale context, we don't foreclose, we forfeit. So a forfeiture of the interest of the buyer or purchaser can only be done outside of court if you have an account servicing agent. If you do not have an account servicing agent, you can only effectuate a forfeiture through a lawsuit, through the court system, which is going to be expensive and take a significant amount of time. So I always recommend in all transactions to have an account servicing agent. The other thing about the account servicing agent and why you would want it as a buyer is because the account servicing agent receives and holds in trust the original warranty deed that's executed by the seller, so that when the final payment is made, the warranty deed is delivered without issue, without hassle, without problems to the buyer. And then the buyer can record the warranty deed and effectuate the actual conveyance of title. So I recommend an account servicing agent. It's not required, but it's an important part of an agreement for sale. Yes, question.
What kind of entity can be account servicing?
A title company, and then there are just loan servicers that are independent, separate from the big loan servicers we think about that have license, I believe, with the Department of Financial Institutions. Because obviously we want to make sure that they're not going to run off with people's money. So there are loan servicers out there that have the proper bonds and licenses in place that can assist with that as well. In fact, Helena from American Title was talking with us earlier, and they have a couple of good recommendations should you ever need one. Give her a call and they can connect you with some good ones that they recommend for these types of transactions. Oh, ability to assign the agreement for sale. So you want to make sure that it says there, right in there, that you have the ability to assign the agreement for sale. Now, in Arizona, many contracts are assignable as long as they don't say that they're not. In fact, most contracts are. However, I've been on the opposite side of arguments where my clients have tried to assign those contracts only to have the other party say, nope, it somehow harms me, or it somehow impacts me, or it is somehow to my detriment, so I don't agree to the assignment. And now, you have a seller saying, I never agreed to allow the agreement for sale to be assigned. Well, you didn't have to. It was silent on that. So I have the right to assign it. It doesn't harm you. But if they come out of the woodwork and they start going to the party that you're assigning it to and making waves and making issues, you have a problem on your hand that you're going to have to deal with. So just put an assignment clause in there that says you have the ability and right to assign the agreement for sale. You want the full ability, and most form agreements for sale will have this, but you just want to make sure that it says that you have the full ability to possess and lease the property. So you want to be able to basically use this property as your own. And then finally, you're going to want a cooperation clause. You're going to want the seller to agree that should additional documents need to be signed, should they need to give authority for you to speak with their lender, should you need to deal with insurance and they need to work with your insurance agent on obtaining insurance, whatever the case may be, that they're going to continue to cooperate and you're going to have their ongoing cooperation with respect to this transaction in the property. All right, let's talk about dispositions for agreements for sale. They are more limited than a traditional warranty deed, with seller carryback financing purchase. So the one is an outright sale to a third party. So you find a third party that's able to purchase the property for more than what you're going to pay to purchase it. And then you open escrow and you basically, essentially almost double escrow it. And you obtain a payoff from the account servicer that you've put in place. They give you the payoff, and then the funds are dispersed, and then the warranty deeds are recorded in that order. And the servicer also can deliver and will deliver the warranty deed to the title company with instructions saying, if you pay X amount of dollars to the servicing agent to pay off the agreement for sale, you can then record the warranty deed. So that's another advantage of an account servicer, is you don't have to worry about the seller figuring out how you're going to work with the seller and talking to them about closing and escrow if you're going to dispose of or do a disposition. You can talk to the account servicing agent. They can give you the warranty deed with escrow instructions that if the amount that's necessary to pay off the agreement for sale is paid, then the title company can record the warranty deed, and then they record the secondary warranty deed on top of it, and now you've conveyed it to a third party. You can assign the agreement for sale, or you can do a second agreement for sale. So you do one agreement for sale in favor of the seller. So you as the purchaser, you do the agreement for sale, and then you turn around and do another agreement for sale to another purchaser. And then you can do a lease with an option. What you can't do and should not do is you can't convey an interest in the property via warranty deed and seller carryback financing, because you don't have fee title to the property at that point. You just have an equitable interest. So you don't have the ability to execute a warranty deed in favor of anybody. So you can't do that. You can't sell it that way via a traditional warranty deed with seller carryback. You don't even have authority to sign a deed of trust against the property, because the only party that has that authority is the fee title owner, which still is the seller until you've performed under the agreement for sale. All right, let's talk about a lease option. So with a lease option, you could, if somebody owns the property free and clear, you can go in and basically say, hey, I want a long-term lease and an option to purchase. As part of that lease, I'll pay you every month X amount of dollars. You know that that's going to come into you, and then I can do with the property as I may from that point forward. And then if I decide I want to buy it, I'll buy it for X amount of dollars, and now you have an option to purchase. All right, now what about a lease option with subject to? So you say, okay, I'm going to lease the property. We're going to keep the loan in place, but you're going to give me an option to purchase the property. What documents do you need? A little bit less than other transactions. So you need a lease, you need an option agreement, you need authorizations to release information, because you do want to make sure that you're able to obtain loan information, especially if part of your lease payment is going to go and pay the loan. One option with the lease is to build into there that instead of paying the seller and then having the seller write checks to the lender, you say, oh, as part of my lease payment, or my only lease payment is I'm going to write a check to the lender for the loan payment, and that's how I'm going to pay rent. And so I write my check directly to the lender, and that satisfies my obligations under the lease to pay the rent. But you want to control that. You don't want to leave it to the seller to then turn around and pay, not the seller, the landlord in this case, not really a seller, right? I'm using the wrong language. It's the landlord. You don't want to rely upon the landlord, the owner of the property, to be paying the loan. They don't pay, you're out that money, and now you're facing a foreclosure, and in order to stop it, you're having to reinstate the loan or do something with the property. So you want to control that. You want to write. So if you're taking a subject to, the lease should provide that you're going to write at least a portion of the lease payment, whatever amount necessary to pay the mortgage. You as the tenant are going to write that check and write that amount directly to the lender. You want authorizations to release information. You want an assignment of insurance proceeds, and you can also build that into the option to provide that, if there are insurance proceeds, and you can even provide provisions in the lease for how insurance is going to be dealt with if there's an insurance payout. You're going to want an instruction letter to the lender, but instead of your traditional instruction letter, you're going to want to say, if the option is exercised, then or if the borrower is going to pay off, that the amount held in the impound account is going to reduce the payoff amount. So if your option basically says, my option is to purchase the property for the amount of the loan, should I decide to, then you're going to want to reduce that payoff by doing an instruction letter. Limited power of attorney for insurance, mortgage payments, etc. You're going to want that as well. All right, let's talk about the lease and the lease terms. You want the ability to sublet. You don't want to be restricted on, you just possessing it. You want to be able to sublet the property. You want the ability to assign the lease. So, if you want to do a disposition, and one strategy would be to assign the lease to somebody else and let them have it, take it over. You want that ability. So you want somebody to basically come in and stand in the shoes of you as the tenant. You want the ability to change locks and make alterations to the property. So the realtor form lease limits the ability to change the locks and make alterations to the property. And we've seen where landlords have come in and basically evicted on long-term leases, or at least tried to evict on long-term leases because the tenant came in and changed the locks and put like smart locks on the property and stuff like that. And it was a violation of the lease terms. So you want to make sure that your lease says, hey, I can make certain alterations. I can change the locks. I can put smart locks on the property. Like if you're going to use it for an Airbnb or something like that, you're going to want that ability to make those modifications. We've already talked about this. You want an ability to make all or a portion of the lease payments directly to the lender. So that's what you're going to want in the lease. The next is your option to purchase. So you're going to want it to basically contain all of the terms of a purchase contract, essentially, which includes, and I'll list down what you want, because what you don't want to do is you don't want the option to be illusory. We have case law in Arizona that says if the important substantive terms of the option are missing, you don't have an option. So you want to make sure that the minute you serve that notice of intent to exercise that option, that you have every term spelled out in that option of what is needed to close. So, you know, who's going to pay what closing costs? Who's going to pay the HOA amounts? Who's going to, what title company are you going to use? What happens if that title company is out of business? And you're going to want those types of terms in that contract so that there's no backing out. There's no saying, well, I wouldn't have agreed if we were using this title company. No, it's in there. We know who we're using. You've agreed to it. We're moving forward. We're closing the transaction. You're also going to want a cure notice. So if you've exercised the option to purchase, you're going to want a provision saying, hey, if you can't close by the scheduled closing date in this option to purchase, you have 3 days, you have 10 days, whatever it is. So you have a little bit of a buffer there to cure, just like you would in a standard purchase, in a standard real estate contract. And then finally, you want assignability. You want the ability to assign the option to purchase. All right, let's talk about dispositions of property subject to a lease with the option to purchase. So you have an outright sale to a third party. So you could, if you find a third party that's willing to pay more than your option price, the amount that you're going to pay according to the option, then you exercise the option, enter into a contract with the third party, and then you close it all in one escrow. The optionor receives, or the seller receives their money, you're paid, and then you execute a warranty deed in favor of the new buyer. So 2 warranty deeds will be recorded, but you can close and receive payment that way. The next is you want the ability to assign the lease an option to purchase. So you want the ability to say, okay, this is a great deal. Somebody else may want this deal. I want a little bit of cash. So you assign the lease and assign the option to purchase. And then finally, you could sublease with an option to purchase. So you could do your own sublease with your own option to purchase to somebody later on. I think that's called a sandwich. Am I getting that right? A sandwich lease option? Yeah.
Would it be appropriate to have a servicing agent take?
You could. It's not as common in a lease scenario because a lease requires an eviction. And so the eviction is a fairly expedited process, but you could do it, especially if your payments are going to be made to the landlord directly, or a portion of the payment's going to be made to the landlord and a portion going to pay the mortgage. You could do a servicing agent in that case. The only downside is there's an extra cost, right, associated with that. All right, so those are the dispositions on lease options. You can't do an agreement for sale. You can't do a warranty deed because you don't have title to the property. That's how you would dispose of lease options or do dispositions on lease options. Any questions? Yes.
Lease with an option to purchase. Usually, is there a term limit for that contract? 2 years, 5 years?
No, there isn't. So leases, I think, like are 99 years. I'll have to ask my partner over here, Andy, probably knows that better than I do, but I think you can lease up to like 99 years in Arizona. So you can lease for a long period of time. You can make it 10 years, 15 years. There is no limit.
But when we're doing a contract, what is it on?
Well, it's what you can negotiate with the seller, but 5 to 10 years is well within the range of what you can negotiate as far as a lease option.
To get a lease option to acquire and then sell for maybe 5 years, and do a 3-year and you sell it, you got 2 years. You get another buyer that does another lease option tenant that doesn't have, because the person doesn't execute. You can use some of that new option fee, pay an extension to sell it. The original lease option that allows, if they're willing to do that, to extend your option again.
Right. So Tristan, his recommendation would be, if you're acquiring the property with a lease option, to do a 5-year, but if you're doing a disposition, and so you're gonna execute another lease to somebody else with an option, that you do a 3-year on the disposition. So good comments. Any other questions? Yes, Brian.
So we just currently went through a situation, actually this week, it was Vegas, and they have a VA loan. And the seller's been super cool, it's about 70K in equity, and we originally wrote it up as a subject to. However, Magnus in Vegas said this is gonna, trigger the on sale clause because we're gonna notify the transfer. And, we don't recommend doing it this way. And we were like, okay, so if we do an agreement for sale, does that not maybe record? Because now you don't have to record to the 5-year option to give him this rest of his 55K is up. Like, and we just kind of hold it, he signs it, and it's not recorded, so nobody actually notifies the mortgage company.
Did you see the VA loan?
Yeah.
VA is assignable.
Assumable, but yeah, but VA is assumable, which means you have to go through their processes of assuming and qualifying and, yeah. Yeah. So I don't know the laws of Nevada, but if you were here in Arizona, you should not just hold the agreement for sale in perpetuity for a couple of reasons. Number one, that seller could then sell it right out from under you. Number one, and number two, the agreement for sale has to be of record in order for the seller to generally be able to go through the notice procedures for the forfeiture of interest. And so generally you're going to want that, or the seller's going to want that to be recorded. Now you can close on an agreement for sale knowing the risk of no title insurance, but you can close on an agreement for sale outside of escrow record. And there's no requirement, at least here in Arizona, that you provide that document to the lender. What would happen is the lender would have to then search the public records and do an audit of that file and discover that document. And not only that, but then decide they want their money now. And so then, go forward with the due on sale clause. So I don't know in Nevada whether the title company has an obligation to notify the VA when they're closing. I know a lot of title companies in Arizona won't do subject to transactions on FHA and VA loans. So I don't know if that's the same thing that you're dealing with there in Nevada. I don't know.
We also heard the agreement for sale, we exhibited it with, like a deed for release and reconveyance to be signed ahead of time, so when we satisfy the terms, we just date it, it's already recorded and done. And then we carried a memorandum to make sure that, we need to try to make sure that they don't sell it out.
You can record a memorandum, but
we were going to cloud title instead of recording the deed.
Well, yeah, so you can record a memorandum of an agreement for sale, but it's still a public record that the lender could see if they ever audited their file. I mean, anytime you record something, with the county recorder's office, it's public record, and a lender could discover it or find it.
It's less, I guess, risky than them just notifying them of the deed transfer.
Correct. I mean, yeah, if you can record, there's no obligation, legal or otherwise, to notify the lender. I mean, there's nothing in the, you can look at the deed of trust in that case, but
we did a subject to.
where you take title via warranty deed. Yeah, I don't know what Nevada's laws are on that, so you may want to,
insurance, we were also kind of trying to figure out, like, is it better to do double insurance, or do you just get an insurance, disclosure allowing them to change the insurance?
So for insurance, there's a couple of options. You can see if their insurer will allow for you to be named as an additional insured under the existing policy.
Which is the first step. And the second step I'm hearing is now that we're on the policy, now you switch, you're the primary and they're the secondary.
Yes, and now that goes to the lender. And so the lender is going to see that a new primary insurance holder is there, whether or not that triggers anything in the lender system to invoke the due on sale, or at least look into the transaction, decide whether or not. Now, I want to make clear on the due on sale clause, conveying title to property with a due on sale clause is not an immediate breach of the loan documents. What that does is it gives the lender an additional right under the loan document should they choose to enforce that right. And that right is the ability to accelerate the loan balance. So it's not, hey, you're in breach, immediate breach. No, it says if you sell it, we have a right, and we may, at that point, choose to accelerate our loan balance, but it's still discretionary with the lender. It's not an immediate breach. So
I'm under the impression that if a due on sale clause does get enacted, that basically the seller will cooperate to put it back to their name and do whatever paperwork is necessary as a lease option.
Yep.
We still get the same thing.
Right.
We could have figured it out later.
Right. You could put in the subject to addendum that you will, basically enter into a lease with the seller should the lender ever invoke the due on sale clause with the same terms as what you had, payment terms, et cetera, that you had before. Yeah. Right. Yeah, there's some tax benefits you'll lose on a lease with option. Right.
List it for sale and, execute your option before it sells to the next person.
Correct. Yes. Yeah. So what will happen is if a lender invokes the due on sale clause, it's considered a non-monetary event or right of the lender. So they will send notice saying, hey, we understand that you sold the property, and therefore here's a notice that we're going to, if you don't fix this problem, we're going to go and accelerate the loan balance. And normally they give 30 days to fix it. And then,
Last question. The
insurance
is always the one that trips us up a little
bit.
Because we just don't know if we're going to trigger the due on sale clause by doing something with insurance. Is your only advice just to be added as an additional insured, and then once you're additionally insured, then change it over to the perimeter? Or you always recommend just get a second policy, add yourself as an additional insured on the first one, but just pay down $100 a month and.
Yeah, secondary policy is adequate, especially with the assignment of insurance proceeds. So if you're saying, hey, let's just keep the insurance in place, let's not rock the boat here, we'll obtain a secondary policy, you're free to do that. And remember, if you do an assignment,
money though, or is it like
but so you're the investor and you're the one that has to decide the risk that you're willing to take versus the cost.
Who does double insurance? You got caught by not doing it. No, you wouldn't do it. No.
So right, so Augie would just add himself as an additional insured under the policy, right? Yeah. Yeah. So I think the majority opinion is to add yourself as an additional insured. I do think and I know that there's investors that are more conservative than that, and they say, well, I'm just going to get another policy. So there's no right answer. It's your risk tolerance, right? The cost benefit analysis. Do I want to pay an extra $100, or do I just want to add myself as an additional insured under the policy?
And then outline it in insurance payout.
Yeah. Right, the assignment of insurance proceeds basically says states you get the, yeah.
The due on sale, if the lender calls it due on sale, it's still somewhat negotiable with the lender.
They normally give you 30 days to fix it.
Say, hey,
and
I can't get it done in 30 days, we need an additional 60 days.
Maybe, but, or,
one's for us.
okay, good. Well, there you go. You can do it. Everything's negotiable, right?
Yeah.
So,
there are times you can do
yeah.
It's on the market. We just have to get it under contract to sell it, whatever.
Right.
They're gonna get their money.
And honestly, if they go a judicial foreclosure, which is what they have to do, I mean, until a judgment is entered, which is going to take 6 months to a year, if not longer, you have that time to sell the property anyway. So there's opportunity there to resolve the issue, should they invoke it. Yeah.
Unless it was assigned to the next person, it's assigned to the next person.
Well, yeah, but that's somebody else's problem right at that point. But yeah.
I heard there's a chain and always goes back to who actually.
Oh, absolutely. Yeah, you would have to undo the chain, put it back into basically the seller's name, and then do another chain with leases and options and whatnot until you get to your final end buyer. Yes.
I have a two-part question. So the additional interest that you, additional insured that you mentioned, does it give, in let's say in a lease scenario, does it give any additional protection to the landlord?
No, adding you as an additional assured provides no additional protection to the lender. It just provides additional protection to you as the purchaser of the property.
Okay. No, not purchase. It's just pure lease scenario. So your tenant, your landlord. Tenant buys a renter's policy and puts the landlord as additional insured.
Oh, sorry, I misunderstood the question. So yeah, if you as the tenant put the lender as an additional insured under your policy, under your renter's policy, yeah, it provides the landlord additional protection. Not the landlord, the lender additional protection.
The landlord.
Yeah, yeah.
And the second question is lease with option to purchase. So if it turns out to be that the buyer who becomes a tenant also, you know, there are some unforeseen circumstances. Like I had a tenant who got into drugs and it went downhill from there. They destroyed the property. In this case, with lease with option to purchase, the new buyer / tenant gets into similar scenario and starts destroying property. What recourse does the seller?
So you're talking, so.
I'm sorry, so can they evict the?
Yeah, and they can evict the tenant and so who's the tenant? The tenant, is it sublet or is it just one lease?
One.
So a lease from the seller or the landlord, the original owner to say you as the.
Yeah, say I'm the landlord.
Yeah.
And then somebody else, let's say he came and he did a lease with option to purchase.
Okay.
So now, I'm sorry, I don't mean anything. But let's say tenant got into drugs and started destroying the property. But he's also buyer at the same time, right? So does the landlord have an option to evict?
Yes. Yeah. So most leases will have a crime-free addendum that basically states, hey, if you're engaged in criminal activity on the property and we can prove it, then you're out. And it's an immediate ouster. I mean, you have immediate right to evict in that case. You know, you don't have the ability to fix the problem, to cure. It's immediate. So yeah, most leases will have a crime-free addendum as part of it that allows the landlord that immediate right.
What's the definition of immediate?
Means you still have to go to eviction court, but it means that you don't have to give the tenant the ability to cure. So under Arizona Landlord Tenant Act, there's certain breaches that a tenant can engage in that you have to give the tenant notice and opportunity to cure before you can evict them. And if they cure it within that time period, you can't do anything. Criminal activity on the property is not one of those. It basically says once they start committing crimes on the certain crimes on the property, they're done. You can basically tell them you engaged in criminal activity. I'm going to evict you tomorrow, and you can go forward with that eviction. Yeah. Yes. Good question. Dodd-Frank's only applicable to residential properties where the purchaser is an individual who intends to reside in the property. If it's raw land, no Dodd-Frank concerns on raw land. Yes, Tris.
I was told 2.5 years ago, some very smart tenants is if you have them move in, schedule your maintenance guy to go and show them how to change the filter. They take the filter away, you can do a drugs test on it. Basically see if they're using drugs. I mean, it's just something I was told I don't actually do. But that way you've got an idea if they're no good by taking the filter out and just showing them that they changed the filter, you just take it away. If that's something you choose to do, that would be handy.
Yes, Brian.
Good. So I have a question. When we first started doing lease options, we were just like lease option, lease option, lease option. But then we started seeing the prices go up 100 grand on their option. And we were like, well, wait, how do we get that 100 grand? And so we started switching our paperwork to say at appraised value or option price, whichever is higher. Is that Is that a good thing to do on lease options? Because now you're getting the 100 equity if they execute their option, but still, not able
Yeah.
to move from the house, and it wasn't really any pushback. People, they just signed it, like, they were just like, yeah, so I can purchase it at appraisal amount, or
So the option is the lesser of whatever the option price is as of that moment, or the appraised value of the property, whichever is less, the lesser of those two, right? Or no? You want the higher. So, okay, so you're doing it,
We noticed.
you're on the back end of the lease
8
option.
properties in the
Yeah.
lease option, they all went up 100 grand.
Yeah,
You lost 800 grand.
that's a good strategy.
Simple verbiage
I mean,
in the
it-
contract.
Yeah, so you put in there that here's the option price, or the fair market value as determined by a licensed appraiser selected by, and you put in who's going to select that appraiser, right? Presumably you as the
It
optionor.
would have to be a bank order appraisal.
Okay, so
They'd have to get a mortgage on it, they can't just
right.
pay
So yeah, it would be the appraised value as obtained by the optionee's lender or the optionee. Yeah, you could do that. Make it the higher of those two.
And we just limited it.
Yeah.
It couldn't be a cash close, it had to be a cash mortgage.
Yeah, you could do that.
I'd highly recommend it. Cost us $800 grand.
Any other questions? Well, thank you all for coming out. I'll bring Augie up to close us out here.
Thank you, guys. We still have the food and drinks out there. Stick around. Let's network. Let's just introduce each other and just have fun. Thank you.
Awesome. Thanks for putting us on.
Thanks, Augie.